Good evening. Good evening. Good evening. I'm Leonard Baines, Dean of the University of Houston Law Center. I want to welcome you to the Ruby Kless Sondock Juris in Residence program. And we're very welcome and very happy to have former Chief Justice Nathan Hecht as our keynote speaker. But we also have Ruby Sondock, Ruby Kless Sondock, who is one of our most notable alums. She is a graduate of the law school in 1962. She was one of only 5 women in the law school class at the time. She graduated valedictorian of the law school. Right after graduating, she argued her first case before the Texas Supreme Court. She became the first woman to be a district court judge in Harris County, the first woman to serve on the Texas Supreme Court. She's a trailblazer, a path setter. She's just amazing. I know she doesn't like to be, she doesn't like all this praise. But when we started this program to bring jurists in residence at the program into the law school, I said to her, we're going to make sure that the Sondock name blazes across the Texas sky. And I think that's what we're doing by bringing such notable, talented jurists to our law school community. So thank you, Justice Sondock, for all you've done. Thank you for being one of our incredible alums. And just thank you for being you. Thank you, Justice Sondock. Let's give a round of applause. And we have some notable judges in our audience. So first is Judge Sophia Andregay, who's actually going to be a recipient of the Ruby Kless Sondock Award from the HBA for her own trailblazingness. Judge Andregay was on Articles of our Law Review. She's a noted corporate attorney. She produces volumes of literature on all different types of corporate issues. She has a regular CLE on this, and she's been on the inaugural member of the Texas Business Court in Harris County. So let's welcome Sophia Andregay. And then we have Grant Dorfman. Where are you, Grant? Judge Dorfman? Oh, there you go. So Judge Dorfman is not one of our alums, but it might as well be. He serves as advisor to the Houston Law Review. He has been an adjunct professor, and he also serves on the Texas Business Court. So welcome, Judge Dorfman. And then we have Judge Ken Wise, who's on the 14th District Court of Appeals. He's also one of our alumni. We welcome you here as well. Judge Wise, thank you for being here. And then we have a lot of judges in the house, to be honest with you. Last but not, no, apart from the speaker, we have Judge Priscilla Richmond, who was the chief judge of the 5th Circuit Court of Appeals. She's currently on the 5th Circuit Court of Appeals. She had been on the Texas Supreme Court. She's not one of our alums, but we accept you and adopt you. She's a Baylor Law alum. She went to Baylor undergrad. She, as I told the audience this afternoon of students, she had scored #1 on Texas bar exam when she took the bar exam several years ago. We've actually had 11 students score in the top 3. Texas is one of the states that actually catalogs who has scored #1, 2, or 3, not 1 or 2 or 3%, but #1, 2, or 3, and she was numero uno. So, and she's been very active, like Chief Justice Hecht, in services to indigent individuals to make sure that there is opportunities for access to justice. She's been involved in gender fairness, among a variety of different things. So we're very, very appreciative that she's being here. We did an earlier fireside chat where I interviewed both judges, Judge Hecht, Chief Judge Hecht, and also Judge Richmond at the same time, which was great, and I think the students really enjoyed it. So let's welcome Chief Judge Richmond. And then last but not least, but our keynote speaker, our Sondock Lecturer, which is Chief Judge Nathan Hecht. He was Chief Judge of the Texas Supreme Court. He was the longest-serving judge on the Texas Supreme Court. He had, over the course of his time, authored 7,000 pages of opinions and heard more than 2,700 oral arguments during his tenure. And he's also been very involved in legal services and making sure that people who have limited means have a great deal of opportunities to have representation. Chief Judge Hecht received his bachelor's degree from Yale University and his law degree from SMU. He had clerked for Judge Roger Robb of the U.S. Court of Appeals for the District of Columbia. He served as a lieutenant in the U.S. Naval Reserve. He had practiced for the, I guess, former firm Locke. I mean, it has another new name, which was a Troutman Pepper Locke. So it has changed names multiple times in the past few years through mergers and whatnot. And he's also served as the district court, among others. He's now a partner at Jackson Walker's litigation practice in Austin, Texas. And so we're really delighted that you're here. He's also very involved in the ABA. I've worked with him and spoke to him. He's on the ABA Council for Accreditation for Law Schools. And he's been very, very active in the Conference of Chief Justices, State Court Judges. He was actually longest serving member of that group as president of the Conference of Chief Justices. So we're really excited that he is here. He's going to be talking, as title of his talk is called, "Whose Side Are You On, Judge? Ours or Theirs? Judicial Independence in a Riven Civitas." Am I pronouncing that correctly? Sort of. He's going to talk about the independence of the judiciary. So who would be the best person to talk about this at this time but our former Chief Justice of the Texas Supreme Court, Nathan Hecht. Welcome.
Well, thanks very much, Dean, for that generous introduction, and thanks to all of you for being here this afternoon. It is a great honor and privilege for me to be here under the name and auspices of Justice Ruby Sondock, formerly of the Supreme Court of Texas, as well as the other judges whom you have met. We elect judges in Texas, as you know, on partisan ballots, some 1,800 of them. In my view, partisan elections are deeply flawed because they risk injecting politics into judicial selection and then judicial decision-making when that has no play in judicial decision-making. In 1982, when Justice Denton's unexpected death created a vacancy on the Supreme Court of Texas, it fell to Governor Bill Clements to fill that seat, and Governor Clements was the first Republican governor elected in Texas history and only the second Republican state office holder elected in Texas. Justice Sondock had been elected to the district court here in Houston as a Democrat. There were a few judges in Texas who had run on the Republican ballot, including me. But Governor Clements ignored politics to appoint the best judge in the state to the Supreme Court of Texas, and that was Ruby Sondock. The first woman to serve in the regular session of the court was as apolitical a judge as the appointment that put her there. She's been a role model for judges since then, especially me, especially because 6 years later I took the same seat on the court that she had held only 6 months, 6 years before. So it's especially fitting for me to be here with her to talk about, as the dean says, whose side are you on, Judge? Ours or theirs? Judicial independence in a Riven Civitas. And really, I mean, we're talking about this, but we are almost every day. The idea that judges should take sides should be abhorrent, but that's much of what you hear. The last thing in the world we want is somebody walking into a courtroom, any court, looking up at the bench and not trusting that the judge will decide fairly based on the facts and the law, but wondering whether the judge will be on their side or on the other side because of their politics. In Texas, political contributions might have been made. Did that influence the judge? Religion, race, gender. In family courts, with the future of parents and children at stake, or in a teenager's misdemeanor drug case, or a personal injury case, or an eviction case, or in federal court, is that what we want? It cannot be perceived as who's on whose side and still be justice. What we want is for everyone to walk out of the courthouse every time thinking, thank God for fair courts. Thank God for the American justice system, for real justice. The promise that I always heard when I was in civics class in junior high school turns out it really is real. It's just happened to me. Equal justice under law. But I was reading of the president's many denunciations of the judiciary, accusing courts of usurping power and judges of being politically motivated, warning of judicial tyranny and undermining the Constitution, and even going to the extreme of calling for the impeachment of Justice Samuel Chase. I was reading, of course, Chief Justice Rehnquist's book, Grand Inquest, which recounts the Senate trial of Justice Chase, and the person of whom I speak, of course, was President Thomas Jefferson. Fooled you, didn't I? You thought I was talking about another day. President Jefferson deplored the thought of judicial independence. The Constitution he wrote is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they may please. What a great tweet that would have made. What a great social post. If only he'd had it. He believed that judges were no less immune from ambition and influence than other holders of power, and should therefore be directly accountable to the people, elected like other officials. Alexander Hamilton took the opposite view. He argued forcefully that judges could be fair and just only if they were appointed for life and independent of any constituency other than the faithful adherence to the rule of law. Justice, Hamilton wrote, is the first duty of society. I think Jefferson agreed. But who was right on how to get there? At first, Hamilton won. Article 3 of the Constitution, federal judges appointed for life. Marbury versus Madison in 1803. Judges get to decide among the three branches, they get to decide what the law is. SCOTUS decides what the law means and what it should be, based on the Constitution and laws that have been enacted in society. But the debate about judges goes on. The political branches have always chafed against judicial independence. Don't have to go back further than FDR. When the New Deal programs that he had initiated, and he thought they were absolutely necessary to escape the Great Depression, were being struck down as unconstitutional one after another by the U.S. Supreme Court. That was FDR. Justice Obama famously decried Citizens United in a State of the Union message with the Supreme Court sitting right there in front of him, talking about how awful their opinion was. President Trump, in the first administration, referred to a decision that he didn't like as being made by a, quote, Obama judge in the, quote, unfair Ninth Circuit. Chief Justice Roberts, that's more than he could take. He responded, "We don't have Obama judges or Trump judges. We have an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them. That independent judiciary is something we should all be thankful for." And the president responded, "Well, then why do we get so many bad rulings from only a handful of judges, all in the Ninth Circuit?" Then Senator Whitehouse from Rhode Island, one of the leading Democrats in the United States Senate, as far to the left as you could get from President Trump, said, "You know what? I agree with President Trump. I don't like his tactics. I don't like what he's doing, but he's right about the judges. They take sides. Only they take his side, and they should be taking our side. They show no respect," he said, quote unquote, "for precedent, federalism, originalism, or judicial restraint." The election of President Biden didn't end the attack on judicial independence. Everybody just switched sides. Reactions to the Dobbs opinion in 2022. The Biden Presidential Commission on the Supreme Court. Its proposals were to enforce term limits on Supreme Court justices and call for an expansion of the court just exactly like FDR had done, 80 years before. Calls for impeachment of judges were ongoing throughout the change in administration. And now in the second Trump administration, the fury has not ended, it's grown even louder. Deportation decisions. The president denounces them. The left says judges are standing up for civil liberties, issuing nationwide injunctions to prevent constitutional violations. Hooray. The right says they're all activist judges. They shouldn't be doing what they're doing. The right says, oh, hooray for the Supreme Court. They're curbing all those practices. The left says the Supreme Court's a tool for the president. Tariffs. I don't need to go through all these decisions. Tariffs. The president decries tariffs. He said the justices who participated in that decision were what? An embarrassment. An embarrassment to themselves and their families. The decision was a disgrace. The other side says, the left says, oh, thank goodness we finally got rid of those tariffs. So it goes both ways, switching week by week, all of the time, with one thing coming out of it all: the judges are taking sides, and they just ought to take my side. We won't go into birthright citizenship. We'll see what happens there. So, did Jefferson win? Has he won the debate? It's better to have judges in politics, pressured by the system. Well, let's ask the people. Let's see what they think. We take polls every year of what the people think about judges. Almost all of the polls are about state judges, but we take some polls about federal judges. There are 30,000 state judges, we don't know exactly how many, in the United States, about 1,700 federal judges. There are about 400,000 federal cases a year in the federal courts. There are 70 million cases in the state courts. In at least 3/4 of the civil cases, where you're not entitled to legal representation in the case, as you are in a criminal case if you're indigent, in at least 3/4 of the cases, one side or both do not have a lawyer. So in 15 million cases, one side or both doesn't have a lawyer, and all of the studies show that if you don't have a lawyer, you're more likely to lose when you shouldn't. So is that equal justice under law? It's not really any surprise then, is it, when we ask the people, do you trust the courts? In 2012, 75% of the people said absolutely. In 2024, 63, down 12%. Thank goodness we're ahead of the Supreme Court of the United States. They're down to 54%. So at least we can brag about that if we wanted to. But when they're asked, do you believe that state courts provide equal justice to all? In 2014, 62%, almost 2/3 of the people asked said yes. Only 1/4 of the people said no. In 2022, for the first time since we've been taking these polls in over 25 years, only 43% said state courts provide equal justice to all. 49% said no. Now it's almost even again, but that's hardly anything to brag about. And here's the one I worry about even more than that one. Do you believe state courts are political? In 2014, 48% of the people polled said yes. 2024, 59%. And here's the thing. In that poll, the people who responded were asked, do you identify as on the left or on the right? And people answered that question. The people who do not think, who think that the courts are political, same on the left and the right. There's no variation based on your side of the political spectrum. So here's what I think. The loss of public confidence in justice system is due to accusing justices of taking sides and encouraging them to do so on one hand and on the other. Jefferson was right about this. Removing judges from popular political pressures with lifetime appointments can invite lack of accountability and even judicial overreach. But he was wrong about this. Subjecting judges to popular political pressures destroys public trust and confidence in the third branch as an institution. In the end, Hamilton was right. If there is to be a rule of law, judges must be independent of the popular political pressures that roil the other two branches. The polls are strong evidence, if not, as I think, proof. So, what are we going to do about it all? Well, first of all, it's a free country, so you can say what you want to, and judges are not above criticism. They're not. It's criticism of judges and their opinions. It's not out of bounds. There's no First Amendment exception for judicial criticism. You can say of them the same thing if you can say of officials in the other two branches or anybody else, with limits like you can't yell fire in a crowded theater. You can't encourage vindictiveness or violence. You have to speak within certain limits, but the limits are very broad. And inciting violence, while it may not be protected speech, it's awfully hard to get to the point where you are being able to rein it in. So you can talk about judges. What you hear in the press day after day, in the social media, from whomever it comes, from the President of the United States, from members of Congress or the Senate, from law professors, of whom there are many commentators in the public sphere, and from even just public-minded citizens who think, you know, that case was wrong, this was wrong, I'm not sure the judges are going in the right direction, I'm not sure that the judicial system is being as fair and equal to all as it should be. That's certainly within bounds. But we do have to ask ourselves, at what cost do we do that? So let me think about that for a couple of seconds. At what cost? First of all, it ought to be totally out of bounds to threaten judges with physical violence because of a decision that they've made. We surely ought to be able to agree, left and right, whatever the issues, that goes too far. Justice Scalia famously said years ago, I attack ideas, I don't attack people. And some very good people have some very bad ideas. And if you can't separate the two, you got to get another day job. That was his view of the work that he did. But many of the comments that you see today come very close to personal attacks on judges, threats that are, if not criminal, on the verge of criminality. We have a real problem with security of judges in the country. The U.S. Marshal Service reports that threats against federal judges are up. We don't have any similar reporting in the states, but DPS here in Texas and law enforcement in other states will tell you they're up there too, and trending up as people who read about cases or reactions to cases and they get very frustrated and they say something maybe that they don't really mean, but turns out to be really a threat of violence against the judge. You've just been reading about one of the Supreme Court justices out on the speaking circuit said that another justice on the court has a privileged background and can't understand day workers, hourly workers. Having been a judge for a long time, I understand that we feel very strongly about cases and how they should come out, but translating that into some sort of slur or assault against the person of the judge not only attacks the judge, but the judge's family, the people who work with the judge, because usually these threats are against the courthouse, not just against the judge. So it's clerks and law clerks and law enforcement and jurors and witnesses and participants who are the brunt of these threats. Recently, Chief Justice Roberts was at Rice. You all saw that in the last couple of 3 weeks. And he said, quote, "This has got to stop." Well, you can say that, but we really need to make sure that there is some reverse pressure of some sort, some denunciation in bar associations or the press or community community involvement that says this is too far. We need to go back and stick to the issues. Whatever you think about the tariff decision, whatever you think about the birthright citizen decision, the judges who are wrestling with those issues are doing their very best to come out as nearly as they can, as close to the law as they can see it. This is not a political issue that you're voting for one side or the other that lost the election. This is an effort to try to get the justice done equally and fairly. I already talked about physical security. There shouldn't be attacks against the justice system or judges. We saw in not long ago attacks made against a member of the Supreme Court, somebody crouching in his front yard and threatening harm to him, physical harm to him. The trial of that case, reactions to the trial, but the point is that it's ongoing, and we have to, as stewards of the justice system and the promise of fairness, have to respond to that. There can't be institutional attacks, and again, we should respond to that. Judicial opinions threatening the end of our society, if not civilization. You know, I exaggerate about this much, but that's what many of the opinions say. They say the world has come to an end, and you think, I remember a Peanuts cartoon. I've got it hanging on my wall, and one of the characters says, is listening to the ball game, and he said, they're playing as if the world has come to an end. And he said, oh my gosh, the world has come to an end. They all go running around and they scurry and they go and hide in Snoopy's house. And one of them says, really, can it be that? Can it be the world is coming to an end? I thought Elijah was to come first. There is some exaggeration there. But I think, don't you think that accounts for some of the scores, some of the low scores? When you ask people, what do you think of the justice system? Do you think it's fair? Do you think it's fair to everybody? Back question that we never ask in the poll, do you think it's going to be fair to you when you need it? But that's the question lying on the table. And the growing answer is, I don't know, I'm not sure the promise is going to be there. Now those, here I think the response can be a little different, because we should encourage each other on the bench, and as lawyers we should encourage the bench to hold the rhetoric down a little bit. It's, first of all, it's illogical. Why would you serve on a collegial bench with people who would destroy society? If the guy sitting down the table from you really is plotting to destroy society, why are you sitting next to him and just saying, well, I wish he wouldn't do it? So there's not, it's really, the exaggeration is illogical, but it's also destructive. My grandma used to tell me an aphorism that maybe you've heard. She said, it's a dirty bird that fouls its own nest. And again, if this is what's going on in the justice system and on the court, why are you part of it? Why don't you go do something else? And so the response needs to be to the participants in that process. Tone it down, keep it more issue-oriented and not so personal. I've served for 36 years on the Supreme Court of Texas. We had some sharp opinions every once in a while, but it wasn't routine, it wasn't regular, and now it almost never happens. Usually if somebody writes too sharp an opinion on that court, somebody down the hall will say, you know, Nathan, you really want to write that? And you think, I probably don't. And so there's a lot of peer pressure to try to tone it down. But there needs to be more of that, so that the message to the people is, this is a justice system you can trust, that we're trying to get it right. And calling each other names and insinuating that you're not is not helping. This is really a big picture mine because of access to justice, as the dean spoke about. We need to make the justice system more user-friendly. People have joked, it's not really a joke, I guess, that if the courts were a grocery business, we'd be bankrupt, because we just don't care what the customers think. It's our show. You got to sit where we tell you. You got to stand up when we ask you to. You got to come and stay as long as we say you need to. You got to find parking. You got to take off work. All of this for a 5-minute hearing in a custody case or a 10-minute examination in a misdemeanor case. And then fine, after you've lost a day, you can go on about your business. So that just is becoming intolerable to a society that's used to ordering food on one of these and having it delivered. It's just it's not something that we can appreciate in the justice system that is too important for us. So what do we do that? There's, if the 20 million civil cases that I mentioned to you earlier, they don't need the federal rules of civil procedure. They don't even need the Texas rules of civil procedure. They need stylized dockets, differentiation, differentiated outcomes, procedures that are tailored to eviction cases or to debt collection cases. Debt collection is 1/3 of the state's civil docket. That's how big it is. There's lots of cases. And then in family cases where they're all so difficult anyway, some accommodation of that and some way to treat people with more professionally that the justice system is responding to their needs. Again, as I said earlier, participants should come away from court proceedings, even if they lose, thinking, well, at least it was fair. At least I got to make my argument. At least I was heard. So many times in the past, that was the response. You ask a lawyer when the judge rules against him, what do you think about that? And the lawyer used to almost always say, well, I respect the judge. I respectfully disagree. When the jury pours you out, what do people used to say? They'd say, I disagree with the jury. We may reverse this on appeal, but I respect the jury system. We have to return to that balance to make sure that the people have confidence that the justice system is doing its business. Two more ideas, and then I'll stop for questions. One is we've got to improve access to justice. We've worked very hard for the last 25 years to improve funding. Texas funds its access to justice programs, in my view, generously. We always ask for more, but they are always responsive. I went to ask Lieutenant Governor Patrick for money for access to justice for veterans. I wanted $3 million, and he said, thank God for you, Chief Justice Hecht. I mean, what would we be without you? It's wonderful that you thought about this. The budget comes out, zero for access to justice for veterans. I said, I went back over and I said, Governor, I thought we were on the same page on this. I must have misheard you. I thought you, oh, no. He says, you know how this process plays out. You know, it takes a while, and this is not the final budget. There'll be amendments to the budget. It'll be better. The 2 days before the last day of the session, the final budget comes out. There's zero for access to justice for veterans. So I went over there on the last day when it was too late to do anything, and I said, I sure am disappointed, Governor. This is really a pressing need, and I wish we could have gotten something done about it. It's just, Chief, you know how this process works. You'll be back. It was a new idea. It didn't get the headwind that it needed. You'll be back next session. We'll get it done. So I went back to my office. I was sitting there all demoralized, and our general counsel called me about 2 hours later and said the budget office just put out corrections, and there's $3 million for access to justice for veterans. That was a correction. And I told the governor, I said, I'm going to tell that story, and whenever I tell it, I'm going to say thank you to you, because I knew he had done it personally, and that it's more powerful to be Lieutenant Governor of Texas than it is to be Chief Justice. But I think everybody knows that. And then 2 sessions later, Governor Abbott said $3 million is chicken feed. You need at least twice that much. So that's the legislative response to a real, demonstrable, pressing, justifiable need has been to help fund it. Doesn't solve the problem. The problem is very big, but it goes a long way. This is controversial, but about 12 states have authorized non-lawyer professionals, sometimes licensed, to perform what would otherwise be considered legal practice in very limited areas. Maybe only in legal aid, maybe only with the supervision of a lawyer, but in any event, to try to help provide manpower to solve the problem. And of course, I don't have time to talk about it tonight, but AI is changing everything, and it can change the provision of legal aid, and we're working hard to see that that happens. And then finally, I just say to my colleagues, we across the country, not my colleagues here, I don't have a problem with my colleagues here. We've just got to scrupulously stay out of politics. We just got to stay completely out. Judicial independence is the exception in a democracy. It's not the rule. The other two branches don't have it, and so we've got to earn it and show that it is justified, and to prove that President Jefferson's fears were mistaken, and that Hamilton was right. Judges can be accountable to the rule of law even without being elected. And in that respect, Justice Sondock is a model for us all. She was when she was appointed. She is to this good day. And it's a privilege for me to be here in her name. Thank you very much. I'm happy to take questions. Yes, sir.
My question was about the importance of insulating judges, in particular, Article 1 and Article 2 judges, like administrative law judges. Do you think all types of insulation are equal, or should administrative law judges have some different type of insulation that is currently in place?
For one thing, specialized judges like that need to have the specialized qualifications to do the job. So we do not, we expect the district judges in Texas and the county judges, county court law judges, to be generalists. So they may have had a real estate background, they may have had personal injury background, they may have had a contract background, and we don't say that they, because it's one or the other, they're not qualified to be judges. But if you want to serve as an administrative judge in an area that's narrow, like oil and gas, or like real estate regulation, or zoning, or any of the kinds of areas where you have judges dealing with very narrow areas, they need to demonstrate the expertise to do that. And I think there is, this is what I saw, there is more response to the audience, and when litigant after litigant complains that the administrative law judge is not doing it right and is costing me time and money, there's probably going to be a response to that. So there is some of it, and in my view, it's mostly due to the specialized nature of the office. Yes, sir.
Which do you prefer, being a judge or an attorney? And why would you go from being the Chief Justice of the Supreme Court of the second largest state in the country and then go into private practice?
Well, that last part of the question is easy to answer. It's because of this. The people have decided that judges should retire essentially when they're 75. It's more complicated than that, but that's the basic rule. That didn't used to always. That's not always been the case. I think the forced retirement, age retirement, was first passed in the 70s, maybe the late 60s, and it's it's controversial a little bit, but most of the states require judges to retire at some age. Now, in Vermont, that age is 90, so if that's not life tenure, it's pretty close to it. In New York, it's 70. Here, it's 75. It varies across the country. But only in 3 states are judges elected for life, appointed for life, like they are in the federal system. They're all in the Northeast. So that's just something that we've decided. On what did I like best, I thought it was the honor of a lifetime to serve the bench, and I enjoyed the trial bench for the 5 years I was there, and the appellate court for the next 38 years, and it's just it's a real responsibility that feels important and feels worthwhile when you know other people are putting their problems in your hands and counting on a right decision. So that said, I probably would have retired anyway, pretty close to then, just because at some point enough's enough. They passed a bill that raised the retirement age to 79. They offered a bill. It didn't pass. And I told my wife at breakfast that there was a bill, I didn't know about it, to raise the retirement age to 79. And she said, "I'm voting against that." She said, enough's enough. I would have stayed maybe another year or two, but the people have had enough. Who else? Yes, sir.
DC.
Here's Mike.
Courts always have to come up with tests, and obviously personal attacks are off the table, but any thoughts about useful tests for when a court is starting to slide into political turf versus strictly legal?
Yeah. No, not really. My first part of the answer will be you kind of know it when you see it. Sometimes it's very complicated, and sometimes the issues are serious and sometimes they're not. A couple, 3 or 4 years ago, it may be before Justice Wise's time, I can't remember, but one of the district judges in Texas put a MAGA flag behind the bench, and there were complaints. And I thought it was a real credit to the Conduct Commission, the people that judge judicial ethics and discipline. They said, "Judge, take it down. Don't do that anymore." And that was enough because he was not out kind of, I don't know, way over the line. It was over the line, no question about that. Another judge put the the multicolor flag on her bench, and the Conduct Commission said, just take it down. We don't, the judges are people. You can do what you want to on your personal time. Don't bring it in the courtroom. That said, there are some times when the judge is just clearly out of line. We have a commission that Justice Wise is on and has led for years. Those are hard cases because sometimes it doesn't seem like that big a deal, and sometimes it really is a big deal. They, of course, we've got canons of ethics that say, don't do this, don't do this, don't do this. But probably the one at the bottom of the list, of every list that you make, the canon of behavior at the bottom says, don't do anything that would be bad. Don't do anything that would cause people to, that would demean the judiciary, that would cause people to lose trust in it. Well, of course, that's as big as the world. So these days, sometimes the activity is blatant enough that you can just say stop. Sometimes you have to prosecute it. But I think the encouragement, I think short of that, short of going to the Commission of Judicial Conduct, if the local bar association said, this is not good for Houston, that some judge is behaving the way. Back in my day when I was on the trial bench, they didn't come see me, but they came to see some of my colleagues every once in a while, and a group of lawyers from the Bar Association would just come to the judges' chambers and say, judges, you're getting a lot of criticism. And usually that had good effect. But when you read about the serious accusations that, for example, the administration is making against judges, because they are deciding cases on deportation or tariffs or detention or all these issues because of their political leanings and not because of the law, that's pretty serious. But again, we just have to monitor it and try to discourage it every time we can. And again, it doesn't always have to be impeachment. It can be something like, won't you quit doing that? And sometimes that works too. Yes, sir.
Thank you, Justice Hecht. At the beginning of your lecture, you mentioned some statistics, and it seemed like maybe there was more trust by the public in the federal judiciary than the state bench. I'm wondering if you think the reason for that might be the difference between election and appointment, and if so, if you think that difference has some involvement in a possible solution to this problem.
I went into the Supreme Court, and they're about 10 points lower in the rankings than the state courts are. There are polls on the rest of the courts in the federal system, and I haven't seen one in the last couple of years, but before, like 3 years ago, the state courts did a little better than the federal courts across the board. To me, that's not entirely fair because many of the decisions that people react to are federal court decisions. So if you don't like Justice of the Peace's rulings on eviction cases or on debt collection, it's probably not going to make the front page of the Chronicle. If you render a very important decision like federal courts often do, then people are likely to say that they do or don't like the court. Chief Justice Roberts himself has said that the adverse press his court gets hurts the state courts, and I think that's true. It's good of him to say it. I don't know what can be done about it, but I think it kind of flows that way. But the frustration, much of the frustration on the state side is with the way courts are run. It's with how long it takes, how much money, how I've been put out of work, all these things, all these infrastructure costs, which we could work on.
Let's conclude that conversation.
Thank you, sir.
Thank you so much, Chief. Really appreciate it. I also want to acknowledge we have 200 people online to this, including our audience. There's over 250 people. So welcome to the online audience, and thank you again, Chief Judge Hecht, for really a scintillating, interesting, thought-provoking, and very relevant conversation for what we're going through today. So thank you so much.